This is Bruno Larvol and Friends podcast every Tuesday. And I'm podcasting today actually from Brittany, France, where I'm visiting family. And we have the highest temperature on the record. Normally, Brittany is actually kind of cold, but not right now. And my guest today, Judge Bednarz, is a lawyer. And we're going to talk about intellectual property. Before that, I want to say a couple of things. Number one, and welcome, by the way, John, to the program.
Thank you. Thank you.
Number one, we are not talking on behalf of our organization. We're talking on the personal level. Our opinions are only our opinions. Number two, reminding the audience, LARVOL is a SaaS company. We sell software and data in healthcare, mostly to pharmaceutical companies, a lot of it in the area of cancer, oncology. This podcast, LARVOL and Friends, sometimes addresses guests in the healthcare fields, sometimes not. And today we're going to talk with John about intellectual property. So, John, thank you for taking the time today. We're looking forward to talking about a little bit about your background and your professional journey, and then the IP system. I always had personally a great interest in intellectual property, in patents, in business process patents and software patents, which is a super interesting field. And so it'd be wonderful to hear your views on trends and changes and challenges, Alice, and other things in that area. At the end, we will ask you to formulate a bit of a takeaway from this time together. So let me pause and maybe get you first to introduce yourself, and then we'll talk IP.
Sure thing. Yeah, thanks so much, Bruno. So yeah, my name is John Bednarz, and so my background is in computer science, and I've been practicing patent law, since 2008. I started my career in Washington, D.C., and almost my entire career I've been working with tech companies, software companies, to help them obtain patents. I worked for tiny little, garage startups, all the way up to the giant corporations of the world. And there's always something interesting in my day-to-day work. There's always something new coming down the pike. That's what makes it super exciting. But I really enjoy what I do. And like I said, it's awesome. I get to see new things way before they even hit the market. So thank you so much for having me today, Bruno.
Oh, of course, John. Great to have you. When did you decide that you wanted to do IP law? And what was the trigger for that? And then after that, I'd like to ask you about the most interesting or unique or weird IP case that you have met in your career.
Sure. Yeah, so my father is an attorney, and so I've been somewhat interested in law since I was a little kid, but I also kind of always have been interested in science and technology. And so right around when I was in middle school and even high school, I got to learn a lot about the patent system and some inventors. I actually did a project where I met the inventor of the television. His name was Philo T. Farnsworth. And he spent a large portion of his life actually fighting and trying to obtain patents. He was a small guy, right? And so he was battling the big giant corporation, which at the time was RCA. And so I learned about how he basically spent his entire life in the court system trying to get his due for all the inventions and all the work that he did. So that was actually really how I got interested in patents. But yeah, back in high school, and then I decided to go to college for computer science because that was my true interest. And at the time I was like, that'll be a really good, background and major if I do decide to go to law school. Because to become a patent attorney, you have to have a certain background. You have to have a certain degree so that you are eligible to take what is called the patent bar, which is just another test that you have to take. In addition to becoming an attorney, you have to actually take an additional bar as well. But yeah, so I would really credit Philo T. Farnsworth as getting me to where I am right now.
I'm going to ask you in a second about to elaborate on maybe the most interesting case you worked on. But
Yeah.
Before that, the way you described it made me think about the story I heard about someone who invented the intermittent windshield wiper.
Yeah.
Do you know that story?
Yeah, I do. And I there's a movie that was made to present the entire story in the case. I'm not sure, I think it's a fictional take on it. I'm not sure how much of it is actually true, but I know he battled throughout his entire life the same sort of deal. He was the
Yes.
small guy going up against the big giant corporation.
And the idea was that if the wiper moved continuously, it's very distracting and could get you hit a tree or something because it nearly mesmerizes you. And that guy thought, well, he should wipe the windshield, but intermittently, so it breaks that pattern that could be problematic for the driver. And he patented that, or he tried to patent it, I guess. And then that patent was challenged and spent that life fighting it. Him, his brother or something, one of them died before they saw the resolution of it. And I didn't see the movie, so I heard it secondhand. So perhaps I don't have quite the story, but it sounded a bit like a Tesla tragic inventorship story to me.
Yeah, I think it's really kind of a sad story. I mean, he struggled with that probably a large portion of his life, and I think that's the case for a lot of small inventors or small companies that have to go up against and kind of battle the big guy.
And in part because unless you the invention stuff, build a company that builds technology, even if you win your patent and challenge someone else who's practicing your invention, you will your return, your financial upside will be based on a licensing, not on the fact that you could have been a whole company around it. So you still need to build that company and make the product, and that's very hard. And sometimes also inventors are not the best at building companies. These are different kind of skills.
Right. Yeah. I mean, a lot of times, even the inventors that I work with are super smart. They know their tech, but they don't necessarily know how to market it and sell it. You're totally right.
So is there a unique patent that in your career you worked on that you can tell us about? And you can, of course, keep it at any level of generality that you need to.
I've worked on a whole bunch of really interesting things. I've also worked on a whole bunch of weird things. And like I said, it's different every day. One of the things that I worked on earlier in my career was there was a large portfolio of patents related to tech and appliances. So like technology and a refrigerator. And this was years and years and years ago, which has really started to, you see it in refrigerators now. You see, this refrigerator is connected to the internet. This dishwasher is connected to the internet. And at the time I kind of thought, boy, that's pretty silly. And it kind of is in a way. But like I said, I worked on it so long ago that at the time it was kind of a pie in the sky type thing. It's a lot of the things that I work on never really see the light of day. So it's kind of interesting when one of the patent applications that I work on becomes an actual commercial product. I've also worked on some other really cool technologies related to autonomous vehicles and drones and things like that. But like I said, there's always something that's new and interesting almost on a daily basis, which keeps it really exciting.
it reminds me that just like people who are developing drugs, you might be the best chemist in the world, but most of the drugs you're developing, I mean, it might even be that none of the chemistry you worked on is going to become a drug, and you still have a top career. It's brutal, right? Because most drugs never make it. And I
Yeah.
think it's the same odds with patents. The percentage of patents, or even more patent draft or provisional patent that ultimately are issued and then utilized in an actual product, is probably the same as drugs that makes it from the lab to the market. It's like a couple of percent, probably, right? Very small.
Yeah, I mean, the drug patents are totally different, and than a lot of the work I do. The software work, a lot of the stuff I draft, those types of patent applications, and oftentimes it can be, a couple of years before they even get examined by a patent examiner, and at that point it might not even be worth it anymore. The tech could have moved on, but in a lot of chemistry, drug, patent related work, that stuff's, it takes years and years and years for it to go from actually being used in practice. So the incentives are different in that space, which is really interesting for the patent system as a whole, because there's only one patent, right? There's not a tech patent or a drug patent. It's just you file it, and you can get 20 years from filing. That's how long a patent can last. But yeah, so the system is really gigantic, and it has to fit all the different technologies and help inventors protect them.
And then there were a lot of games that people were playing. I remember the term submarine patents, and a guy, was it Samuelson or Lemerson, right?
Yes,
What was the name of
that is
that
his name.
inventor?
Yeah, so that was done a long time ago. There was a way that you could basically just keep filing patent applications on the same invention to continue to protect it until for eternity. You can no longer do that, but they kind of fixed that loophole. But that is a famous case from a couple decades ago, where he just kept continuing to file new applications on the same invention. But you're right; it's called a submarine patent.
And then by the time you build your product, you realize that someone else had a submarine invisible patent lurking, and then they come and sue you or ask you for a lot of money and so on and so forth. So that loophole has been closed. And then there was the whole question of what can you patent in the field of software and in the field of business processes. And I realized that has changed as well. And maybe you can tell us a little bit about the famous Alice, not Alice in Wonderland, but Alice, I guess, versus someone else, that resulted in a drastic change of what can be patented or not. So if I have an idea of a process, which sometimes is what the software does, it just does a process that exists in the real world and codify it into a code, right? So that's a topic that I find fascinating. Maybe you can shed some light on what what is a business process patent and a software patent, and what Alice did to change what can be patented.
Sure. Yeah, so there was some case law from the late 90s, late 1990s, that kind of opened the door to a lot of patent filings. In particular, there were a lot of business method patents. That's what they're called. And basically it was a lot of companies were filing patent applications to protect, basically methods of doing business using the internet, because the internet was booming at the time, and all the .com tech was growing, and so for a number of years, those patents kind of they continued to grow, and eventually the Supreme Court had to step in. What the case you're talking about, Alice, is a Supreme Court case from 2014, and that's when they came along and said, hey, you can't just do something using a computing device that has been done for hundreds of years and try to claim it in a patent. It's too abstract of an idea. It's not eligible for a patent. It's not patentable subject matter. And like I said, that was in 2014, and the courts and the patent office are still struggling with that decision, because in it, they never used the word software. They never explained what an abstract idea was. They just said, you're not eligible for a patent because you're doing something that's too abstract. And so patent attorneys and the patent office and the courts have struggled with this for a number of years. But basically, it's much more difficult to obtain certain types of tech software related patents, especially in the business method realm. It has to be something that improves a computing device, improves technology, and it's honestly, it's made things much more, the patent system is a lot less stable than it was a couple of years ago. Whether that's a good thing or not is a different question.
Did it result in an important drop in the number of software patents filed, or not so much? People just had to work harder to get a patent through.
So for a number of years, in certain technology areas that are, like I said, more related to business methods, it was nearly impossible to obtain an issued patent for a number of years. The patent office was afraid to issue patents in this space. And honestly, for a lot of clients, I had to kick the can down the road and hope that things got figured out. And the tricky thing is, when you draft and file a patent application, you're stuck with the document for a number of years. And so when you're drafting a new patent application, you can kind of learn from the case law and things that have changed, the guidance from the patent office. But at that time, it was just kind of, everyone was confused as to what to do. How do we move forward, especially in business methods in that tech space? So it was tough for a number of years. In my opinion, the pendulum has kind of swung back the other way. There are a huge number of software-related patents, tech patents that are being issued now. So it really is kind of a pendulum type deal. Every couple of years, the patent office tightens things down with respects to allowing cases. But the Alice decision was a very big turning point for the patent system.
Well, one approach I heard about getting around that Alice roadblock, and I'd like to know if you agree or if it's an oversimplification, is that if you can add an AI loop somewhere in transposing something that is done in the real world to something that is done with a computer, now you did something beyond the just abstract transposing of a real life process to a computerized process, and your
Correct.
chances of getting approved go way up. Is that a correct statement, or is that way too simple of a rule?
That can be one approach. So one of the pieces of guidance that the patent office provided in a number of years after Alice was actually about 3 years ago now, is they indicated that you have to have some practical application of the abstract idea, or you have to improve technology or improve the computing device. So oftentimes, pre-Alice, a lot of patent applications didn't explain things in enough detail. But the patent office really wants you to explain now, how do you improve the computing device? How do you do things more efficiently? How do you save processing cycles? Are you saving memory? Are you, how exactly are you doing it? And if you can put that sort of detail into the patent application, oftentimes that will help you overcome these sorts of Alice type rejections.
Yes. Is meta patent a field, immersive technologies, and what we call now the metaverse? Is that a subset of the software patent and business method patent field, or no? It's not actually that different from the rest. It just have a certain type of application. Is that a subspecialty, or and is that one area where you're active yourself?
Yeah, I mean, I think it's going to be really interesting to see what's going to be coming out of that space. I think right now it's just in its infancy, and it typically when you file a patent application, it takes about 18 months for it to publish. So I think that there's honestly been a lot of this sort of tech that has been filed lately, and I think we're going to learn about a lot of that lately, or coming up here in the next few years. In my opinion, I don't think it's all that different than other sorts of software related patent applications. It'll be interesting to see how the patent office examines them. They might kind of say, hey, these are too abstract, and they might get the same sorts of types of rejections, but I think only time will tell. We'll find out.
Yeah. I understand. So, and we have about 8 minutes left. I want to ask you a broader, maybe prediction question about what you see as the trends, as maybe the big topics and the big trends that people in the patent field are tracking or expecting, or maybe even your own personal prediction about how the field of patent law, especially as it relates to tech, where it's going. And I want to add, I know you're a lawyer, always cautious, so I would say for everybody listening, this is not financial advice to invest in any company or make decision on your own accord, not on what John said. Do your own due diligence, or do your own research.
Yeah, no, it's a good question. I think there's some in the patent field, especially in the tech space, that after Alice kind of thought the sky was falling, and that it kind of ruined a lot of the incentive to file patent applications. If you file it and at the end of the day it's not going to get examined for a number of years, and the patent office is going to say it's not eligible for a patent because it's too abstract. And like I said, the pendulum has swung back the other way. So they're certainly issuing tech patents and software related patents. But the other thing that Alice caused was, for a lot of times when a company, whether they're a small startup or even larger, is trying to enforce a patent or license a patent, Alice made it such that it's very, no one knows exactly what you're getting when you get an issued patent, because oftentimes companies, when they're attacked with one of these sorts of patents, the first thing they do is they say, well, this is an abstract idea, and they come back and they try to invalidate the patent and say it's not eligible, and just throw it away. And so it's kind of made the incentives for filing patent applications, especially for smaller companies, much more questionable, simply because of Alice. It's made it really tricky to navigate.
Yeah, and understand. And then if the potential infringer said, well, we don't recognize the validity of that patent, then the amount of work needed and the process and the cost of this is such that the small company doesn't have the resources, the time, or probably the interest to engage into that kind of battle with a big company. And so it does it mean that that type of filing is ready for the Metas and the Microsoft and the IBM of the world, but young companies just don't file patents. It's not part of their strategy. The VCs are not going to ask a small company, a startup, hey, what's your patent strategy?
Right,
Is
right.
that true?
I think for some, yeah, that's very true. I think it's kind of shifted the balance. But like you said, all the big companies of the world, they're continuing to file quite a number of patent applications. They haven't slowed down that much. I mean, maybe Alice has made them question how much they're spending on building a patent portfolio. But yeah, you're right. I think some of the smaller companies, the startups, are kind of getting the, hey, why are you filing in a lot of cases? But like I said, I still do think that there is a lot of incentive to file for small startups, but likely not as much pre-Alice.
Yeah, understand. And then Elon Musk said, "Okay, I'm going to release all of my patents in the free domain, in the
Right.
as open access." What do you think of that?
I think that's, I don't know if I really believe exactly what he's saying there, but I mean, I think he's trying to do the right thing. I don't know.
Okay, so we have 3 minutes left, John. It was a pleasure. It's a topic I find super interesting, and I'm glad you are taking the time to talk with us about it. So in the last minute, 2 minutes, 3 minutes, any sort of summarizing statement or any takeaway? If people can only remember one thing from listening to this podcast, what would it be? What would be your main message in closing?
Sure. Yeah. So I'm from northeastern Pennsylvania, where the office was born. And there's a famous quote from that show, from Michael Scott and Wayne Gretzky: "You miss 100% of the shots you don't take." And so, in my opinion, it can be questionable whether you're going to get a patent at the end of the day. But if you don't file for a patent application and you don't attempt to get an issued patent, you're not gonna get one, right? So that's one of the things that I like to counsel clients, and I want to explain to them that you have to file patent applications if you want to get one. It can be very difficult, and it's very unpredictable whether you're going to get one at the end of the day. But if you don't file, you'll never get one.
Thank you for that last word from the great Wayne Gretzky. Thank you very much, John. We appreciate it. Enjoy the rest of the day. And again, signing off from very hot Brittany in France here. Bruno, LARVOL in France. See you next week. Bye-bye.